A Supreme Court fight over guns just ended in a way that shocked a lot of people. And if you only read the headline, you might think the Second Amendment just took a direct hit overnight. Quick question before we go any further. Are you subscribed yet? If not, fix that right now, because this channel is built for people like you who do not want to get blindsided by gun law changes after the fact. I dig through the cases, the filings, and the legal language so you do not have to. And today's story matters because the court just left Missouri's so-called Second Amendment Preservation Act dead in the water, which means a lot of gun owners are about to learn that state-level protection does not work the way they thought it did. Here's what just happened. Missouri passed a law called the Second Amendment Preservation Act, or SAPA, back in 2021. The basic idea was simple on paper. Missouri said certain federal gun laws were unconstitutional, and state and local officials were not supposed to help enforce them. The law also created serious penalties, including a possible $50,000 fine if agencies or officers crossed that line. Now, to a lot of gun owners, that sounded amazing. It sounded like Missouri had built a wall around federal gun enforcement. It sounded like the state was saying, "Not here, not on our watch." And that is exactly why this case got so much attention. But here's the crazy part. The federal government sued Missouri, and the court said the problem was not just that Missouri refused to help. The problem was how Missouri tried to do it. There is a huge legal difference between a state saying, "We will not use our people or money to help enforce this federal law," and a state saying, "That federal law is invalid here." Those are not the same thing. Let me break that down for you in plain English. Under what lawyers call the anti-commandeering rule, the federal government usually cannot force state officers to run federal programs for them. Think of it like this. Washington can ask for help, but it usually cannot order your local sheriff to become a federal agent. That part is real. That part matters. But there is another rule called the Supremacy Clause. Simple version. When a state law directly collides with valid federal law wins. So Missouri may be able to step back and say, "We are not helping." What Missouri cannot do is act like it has the power to cancel federal law inside the state. That is the heart of this case. First, a federal district judge blocked SAPA in 2023. Then Missouri asked the U.S. Supreme Court to step in right away and put the law back into effect while the fight continued. The Supreme Court said no. Justice Clarence Thomas noted that he would have granted Missouri's request, but the rest did not. That is where people get the 8-1 framing. On that emergency request, Missouri effectively lost by an 8-1 split. Now this is where it gets interesting. Justices Neil Gorsuch and Samuel Alito wrote separately to say, in simple terms, hold on, lower courts still need to be careful. Their point was not that SAPA should win. Their point was that federal courts cannot just wave a wand and erase every possible part of a state law in every possible situation. So even inside a loss for Missouri, there was still debate about how broad the lower court's order should be. Then the case kept moving. In 2024, the 8th Circuit Court of Appeals agreed with the lower court and said SAPA violated the Constitution because it tried to invalidate federal law. Missouri then asked the Supreme Court to hear the full case. And in October 2025, the Supreme Court denied review. That means the lower court ruling stays in place. SAPA remains blocked. So what does that mean for you? It means this was not a ruling that wiped out the Second Amendment itself. That is the first thing most people get wrong. This was not the court saying, "You do not have gun rights." It was the court saying, a state cannot protect those rights by pretending federal law no longer exists. That is a very different issue. And if you miss that difference, you will misunderstand everything that comes next. If this is helping you cut through the noise, make sure you subscribe now. My next video is going to cover one of the biggest mistakes people make when they talk to police during a gun stop, and knowing that one mistake could save you from making your situation worse in seconds. Second, let me explain why this matters in the real world, because this is the part nobody talks about clearly enough. Imagine you live in Missouri. You hear people say, relax, SAPA protects us. You assume your local police department cannot cooperate with federal agents on certain gun cases. You assume your sheriff's office is legally boxed in. You assume the state created some kind of shield. That assumption is now dangerous because once SAPA is blocked, that special shield is gone. State and local agencies in Missouri can no longer point to SAPA as the law that stops cooperation or punishes cooperation the way the statute tried to do. In other words, if someone told you Missouri law made certain federal gun restrictions meaningless inside the state, that is not the legal reality now. Here's a hypothetical example to explain this. Let's say a local officer learns that a person prohibited under federal law may have a firearm. Under the old SAPA theory, people argued that state involvement in helping on that kind of federal gun case could trigger legal trouble under Missouri law. But if SAPA is unenforceable, that state law threat is no longer the protection people thought it was. Or imagine a local agency sharing information with federal authorities in a gun investigation. A lot of people believed SAPA made that risky for the agency. That supposed protection is now gone too. And here is the part that shocked me when I dug into the case. Missouri's best argument was not really, we can erase federal law. It was more like, we are just choosing not to help. And the reason we chose not to help should not matter. That is not a crazy argument on its face. But the courts looked at SAPA's actual wording and said, no, this law goes further. It says federal gun laws are invalid to this state. That wording hurt Missouri badly. Words matter. In gun law, one sentence can decide everything. Most people think courts only care about the broad goal. They do not. Courts care about the exact mechanism. They care about what the law actually says and does. Missouri may have had more room to make policy choices if it wrote a narrower law focused only on state non-cooperation. But once it stepped into nullification language, it gave the federal courts a big target. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Also, do not make another common mistake here. Some gun owners hear this ruling and say, fine, then every state law trying to limit federal help is dead. That is not true either. States still do have some power to decline to use state resources in certain ways. The anti-commandeering principle did not disappear. What failed here was Missouri's attempt to mix non-cooperation with a declaration that certain federal gun laws were invalid. That distinction matters a lot. Think of it like this. A state can often say, we are not driving your truck, but it cannot say, your truck does not exist. That is basically the legal fight in plain English. And if you are a gun owner who likes strong state-level protection laws, you should actually care about that distinction more than anyone else. Because if lawmakers write sloppy language, the whole law can collapse. Good intentions do not save bad drafting. Hey, real talk. A huge chunk of people watching these videos never subscribe, and then they miss the next update when a case changes everything. Do not be that person. Join the community, hit subscribe, and stay ahead of the people who only find out about gun law changes after they are already repeating old advice. Third, let's talk about what this does not mean, because bad headlines are going to confuse a lot of people. It does not mean federal agents can suddenly do anything they want. Federal gun laws still have to survive constitutional challenges. If a federal law violates the Second Amendment under Supreme Court precedent, it can still be challenged in court. That fight is still alive in many other cases. It also does not mean Missouri gun owners lost every layer of state protection overnight. Missouri still has its own state gun laws and constitutional provisions. What changed here is that SAPA, as a special anti-federal enforcement shield, is not standing. And this does not mean the Supreme Court issued some giant new anti-gun opinion explaining why federal restrictions are wonderful. That is another important point. When the court denied review in 2025, it did not issue a full merits opinion rewriting Second Amendment law. It simply let the lower court ruling stand. That may sound technical, but it matters. Because some YouTube titles are going to scream, Supreme Court destroys gun sanctuary states. That is too broad. The more accurate version is this. The Supreme Court left in place a ruling that Missouri specific law went too far, because it tried to invalidate federal law instead of simply refusing to help enforce it. That is less dramatic, but it is much more useful. Now let me tell you why this matters outside Missouri. Lawmakers in other states watch cases like this very closely. If a state wants to pass a law limiting cooperation with federal gun enforcement, this case becomes a warning sign. It says, be careful. If your law sounds like nullification, it may get crushed. That could shape future bills across the country. And if you are the kind of person who supports hardline Second Amendment legislation, you should want lawmakers to learn the right lesson here. The wrong lesson is, do nothing. The right lesson is, write smarter laws that stay inside constitutional lines. Here's what most people get wrong again. They think passion wins these fights. Sometimes passion starts the fight, but drafting wins the fight. Language wins the fight. Structure wins the fight. If a law invites a Supremacy Clause challenge, courts are going to look at it hard. So what should regular gun owners take away from this? Number 1, do not trust slogans more than statutes. If somebody says, federal gun law does not apply here, you better slow down and verify that. Fast. Number 2, do not assume your state has created immunity for conduct that federal law still reaches. That is a risky mindset. Number 3, pay attention to the difference between rights litigation and state resistance laws. They are related, but they are not the same battlefield. And number 4, stop getting your legal updates from memes. I am serious. This is how people get burned. A screenshot gets shared around. Somebody says, Missouri beat the feds. Then months later, the legal ground shifts, but the old post keeps circulating. Meanwhile, regular people keep acting on bad information. That is how avoidable mistakes happen. Laws change fast, and court rulings change even faster than the rumors around them. So subscribe right now, because I have another breakdown coming on what gun owners should never assume about state protection laws, and that one could save you from trusting the wrong advice at the worst possible time. Let me leave you with the biggest takeaway. This case was not the Supreme Court killing the Second Amendment. It was the courts rejecting Missouri's attempt to protect gun rights by declaring parts of federal law invalid inside the state. That strategy failed. And if you are a gun owner, the real lesson is simple. Do not confuse political messaging with legal protection. Stay alert, stay informed, and please do not make decisions based on a headline alone. Subscribe if you want clear, plain English updates without the hype, because the next case could affect your rights, your carry choices, or the advice you give your own family. And one last thing, this video is for education only. It is not personal legal advice, and gun laws can change based on your state, your facts, and new court rulings.